Good morning, Your Honour. May it please the Court, my name is Lines, initial M, appearing on behalf of the accused in this matter. Your Honour, pursuant to sections 130 of the Queensland Evidence Act and 590AA of the Criminal Code, the defence seeks to exclude the record of interview on the grounds that it was obtained improperly and in contravention of law. Your Honour, in this case, my client is a 15-year-old Aboriginal male and therefore is a child at law pursuant to section 21AD of the Evidence Act. Your Honour, the defence respectfully submits that the ROI was obtained through breaches of the Police Powers and Responsibilities Act 2000 Queensland, hereafter referred to as the PPRA. These provisions are in place to ensure that any evidence obtained from suspects during the investigation or the interviewing process are done so freely and voluntarily. Firstly, may I direct Your Honour's attention to section 403 of the PPRA, which provides that a person must not be detained for more than 8 hours unless the detention period is extended. Your Honour, my client was arrested at 10 a.m. and charged at 7 p.m. Therefore, he was detained for a total of 9 hours, giving rise to our first breach. May I now refer Your Honour's attention to sections 420 and 421 of the PPRA regarding the special requirements for the questioning of Aboriginal people and children. Pursuant to this, the suspect must be informed that a representative of a legal aid organisation will be notified that the person is in custody for the offence. My client was informed that a legal service would be notified, however, no phone call was ever made. Thus, my client was deprived of his statutory right to legal representation, which in the circumstances, Your Honour, given his age and his capacity as a detainee, was crucial. As a child under investigation, my client's mother was present in the interview questioning. However, she was not given the opportunity to speak to her son in a private environment beforehand, as the Act provides. Further to this, Your Honour, the defence admits that no interpreter was provided to my client, giving rise to a breach under section 430 of the PPRA. Section 25, Schedule 9 of the Police Powers and Responsibility Regulations imposes that if an officer reasonably suspects that the suspect is an Aboriginal person, then necessary questions must be asked first to establish their level of education and their level of understanding. My client is from and still lives in Bamaga and Cape York, and therefore English is not his first language. With great respect, Your Honour, the defence admits that the failure to assess my client for English language proficiency and the failure to provide him with an interpreter gives rise to a breach of section 431 regarding the cautioning and the rights of a person. Your Honour, pursuant to the aforementioned breaches of the pertinent statute, public policy evokes the Court's power to exclude evidence through the application of the Bunnings v. Cross test. The purpose of the PPRA is to safeguard and ensure the rights of and the fairness to persons questioned for an indictable offence. And although the evidence may be prima facie admissible, Your Honour, it was obtained in breach of the standards that are expected within society, and this infers the improper or illegal actions of the police in the process. Respectfully, the police are aware of the PPRA and they're aware of the requirements expected of them, as it is a crucial component of their job and their duty to society. The multitude of breaches suggests that in this case the actions were deliberate and utilised intentionally to economise the process. On this, the defence moves that the ROI be excluded. Your Honour, in terms of the cogency of the evidence, I respect that the ROI in contention formulated the base of my learned friend's case. However, the defence finds it hard to ascertain why more care and prudence was not given to the process of interviewing when the admissions gathered were to be critical to their case. Your Honour, due to the particular provisions that were breached, it is difficult to conclude that a genuine response was taken by the police for the circumstances. In fact, the defence respectfully submits that the opposite took place. there's section 420 and section 421 that were not complied with. No illegal aid was contacted, and which in the circumstances of a 9-hour detainment does not seem genuine. Section 403 was not complied with regarding the aforementioned detainment, for which a genuine response would have been in the form of an extension application per section 405. Accordingly, there is nothing in the circumstances that justifies the demonstrated response. My client was arrested on the suspicion of murder, which if convicted, poses a life sentence under section 305 of the Criminal Code. Therefore, given the severity of the offence my client was under investigation regarding, the investigation should have been carried out pursuant to the PPRA in order to uphold the judicial process. Your Honour, in my final submission, I seek the Court's discretion to consider the Christie fairness method as a further ground of exclusion by virtue of proportionality, whereby the probable effect outweighs the evidential value. I refer Your Honour to the Queensland Supreme Court Equal Treatment Bench Book, which highlights the numerous cultural and linguistic differences between Anglo-Australians and Aboriginal people, which must be taken into account when conducting an interview of a suspect. I direct Your Honour to the Anunga rules, which were developed to specifically deal with the manner in which an Indigenous person should be interviewed by police. These rules have been accepted by the courts through the case of R.B. Wilson, determining whether it is fair to admit an interrogation of an Aboriginal or Torres Strait Islander person into evidence. Further, the guidelines now form a part of the Queensland Police Service's Dairy Manual, which is binding on officers and staff. I refer Your Honour to Rules 3 and 4 in particular, which emphasise the threshold of great care that should be taken in both administering the caution and formulating questions in order to cater for cultural differences. The defence admits that, pursuant to the Criminal Justice Commission's report on Aboriginal witnesses, question and answer interviews are culturally alien to many Aboriginal people, creating problems regarding direct questionings, especially in an interrogation sense. Furthermore, when an Aboriginal person is questioned by a person of authority, of which my client was, in an oppressive situation over a lengthy period of time, and this is evidenced by the breach of section 401, then it has been concluded that they are likely to gratuitously concur with the proposition in order to convey cooperation and avoid conflict. In light of all this, Your Honour, the record of interview ceases to exist at both common law and statute, and therefore respectfully should be excluded as evidence. Nothing further, Your Honour.